June 5th. Write that date down right now. Put it in your phone. Circle it on your calendar. Because according to three separate constitutional law analysts who have been tracking the Supreme Court's current docket, June 5th is the most likely date for a ruling that will directly hit the wallets, the health care, and the legal rights of every senior in America. A 7-2 decision that has been building inside that courtroom for months, and the two justices expected to dissent are not dissenting because the protections are wrong. They are dissenting because they believe the protections do not go far enough. Let me say that again. The expected dissenters in this ruling think it should do more for seniors, not less. That is not a political fight. That is not a close call. That is 9 justices looking at the situation facing older Americans in this country and arriving at the conclusion that the system as it currently stands is failing the people who built this nation. And what they're about to do on June 5th is going to change that in ways most Americans are completely unprepared for. My name is Ray, and I am telling you about this today before June 5th because preparation is everything. The seniors who understand what is coming and take action before this ruling drops will be in a position to access every benefit, meet every deadline, and protect every dollar they are entitled to. The seniors who hear about this for the first time 3 weeks after the ruling, buried on page 7 of a news website, will be scrambling to catch up while enrollment windows are already closing. This channel exists to make sure you are never the second group. Subscribe right now and hit that notification bell because when June 5th arrives, you will want to be watching this channel the same day. What I am about to break down is everything you need to know before this ruling lands. Let us start with what is actually at stake in this case because the headline numbers do not capture the full picture. The case before the Supreme Court consolidates challenges from 14 states and involves a direct constitutional question about the federal government's authority to establish and enforce minimum benefit standards for older Americans. On one side, you have the argument that these protections represent overreach. On the other side, you have 73 million Americans over the age of 65 whose financial security, health care access, and physical safety hang in the balance. 7 justices are expected to side with the 73 million, and the ruling they are expected to deliver will establish constitutional precedent that no future administration, no future Congress, and no future legal challenge can easily unravel. Here is what the ruling is expected to address and why each piece of it matters to your life right now. The first and most immediately felt change involves Medicare prescription drug pricing. This has been the most bitterly fought provision in the entire legal battle, and the reason is simple. The pharmaceutical industry has spent over $2 billion in lobbying and legal fees in the last 4 years trying to prevent one thing: Medicare negotiating drug prices directly on behalf of the seniors it covers. $2 billion. Because the profit margin on the current system is that enormous. Right now, Medicare is the largest single purchaser of prescription drugs in the United States. It covers more Americans than any private insurer, and it has been legally prohibited from using that purchasing power to negotiate lower prices. Every other major government health program can negotiate. The Department of Veterans Affairs negotiates. Medicaid negotiates. But Medicare, your Medicare, the program you paid into your entire working life, has been forced to accept whatever price the pharmaceutical company decided to charge. The result is that American seniors pay dramatically more for the same medications than people in virtually every other developed country on earth. Insulin that costs $30 in Canada costs $300 here. Heart medications available in Germany for $40 a month cost seniors in Ohio $260 for the same pills. This is not a coincidence. It is the direct result of a legal prohibition that was written by lobbyists and passed by politicians who accepted their money. The expected 7-2 ruling will confirm the constitutional authority of Medicare to negotiate drug prices directly and will accelerate the implementation timeline that pharmaceutical companies have been fighting in court to delay. For seniors currently spending $200 to $500 a month on medications, the trajectory of those costs is about to change. Not immediately, not overnight, but on a legally protected downward path that cannot be reversed by a future court challenge or a quiet regulatory rollback. What you need to do before June 5th, call your Medicare Part D plan today. Ask what your current out-of-pocket maximum is for 2026. Ask which of your specific medications are on the list of drugs currently in the negotiation process. Ask what your costs would look like under the new pricing structure once it takes full effect. Get that information now while phone lines are not flooded with millions of seniors all asking the same questions at the same time after June 5th. Now let us talk about Social Security, because what this ruling is expected to confirm about your monthly benefit is something that should make every working American furious that it took this long. The Social Security cost of living adjustment, the COLA. Every year this number is supposed to protect your purchasing power against inflation. Every year the Social Security Administration looks at an inflation index and adjusts your monthly benefit accordingly. And every year for decades, seniors across this country have watched their benefits go up on paper while their actual purchasing power quietly went down in practice. Here is why. The inflation index currently used to calculate your COLA was designed to track the spending habits of urban working-age Americans, people who spend significant portions of their income on gasoline, on work-related transportation, on electronics, on categories that have very little to do with how most retired seniors spend their money. Your spending looks completely different. You spend more on prescription drugs, more on medical appointments and procedures, more on in-home care and assistance, more on heating and utilities. And those categories have been rising in price faster than almost anything else in the economy for the last 2 decades. The practical result is that the official inflation adjustment for Social Security and the actual inflation experienced by a typical senior have been 2 very different numbers. Seniors have been falling behind by 1, 2, sometimes 3% per year in real purchasing power, while being told their benefits were keeping pace with inflation. The Supreme Court ruling expected on June 5th is anticipated to confirm the constitutional authority to implement a senior-specific inflation index, one that actually tracks what seniors spend money on, one that reflects the real cost of living for a retired American. The legal challenges to this provision argue that altering the COLA calculation formula exceeded congressional authority. 7 justices are expected to disagree. For a senior currently receiving $1,500 a month in Social Security, a more accurate inflation index could mean an additional $50 to $150 per month within 2 to 3 years of full implementation. On a fixed income, that kind of difference is not a rounding error. That is the utility bill. That is the copay. That is the difference between getting through the month comfortably and getting through the month worrying. What you need to do before June 5th, log into your My Social Security account at ssa.gov right now. Verify your current benefit amount and make sure your personal information is accurate and up to date. Create an account if you do not already have one. This is where benefit adjustments will be reflected and where action items will appear after the ruling takes effect. Do not wait until June 5th to set up your account for the first time. Now let us talk about something that touches millions of American families directly and almost never gets enough attention: nursing home safety and accountability. If you have a parent in a care facility right now, if you are yourself considering a care facility, or if you are a senior who worries about what happens if your health declines to the point where you need that level of care, this section of the expected ruling is for you. The nursing home industry in America is a $170 billion business. It is also an industry with a documented history of chronic understaffing, safety violations, and in far too many cases, outright abuse and neglect of the most vulnerable people in our society. Federal inspection data consistently shows that a significant percentage of nursing homes receiving Medicare and Medicaid funding have been cited for serious violations. Inadequate staffing ratios, medication errors, falls that could have been prevented, residents left in unsafe conditions for hours. Industry groups have spent years challenging minimum staffing requirements in court, arguing they are economically burdensome. 7 Supreme Court justices are expected to look at that argument on June 5th and say that the economic burden of the nursing home industry is not more important than the physical safety of the seniors in their care. The ruling is expected to confirm mandatory minimum caregiver-to-resident ratios with teeth, penalties for violations that are large enough to actually hurt, transparency requirements that give families real access to inspection reports, staffing data, and violation histories before they make decisions about where to place a loved one. What you need to do before June 5th. Visit Medicare.gov right now and use the Nursing Home Compare tool to pull the current inspection report for any facility you or a loved one is currently in or considering. Read it carefully. Look at staffing levels. Look at health inspection results. Look at any cited deficiencies, because after June 5th, those reports will be updated with the new required data, and you will want the baseline comparison. Let us talk about elder financial fraud, because this is the threat that will reach into your home, whether you have a gun in your car or not, whether you take medications or not, whether you are in a nursing home or living fully independently. This threat does not discriminate, and it is getting more sophisticated every single year. In 2025 alone, elder financial fraud cost American seniors an estimated $37 billion. $37 billion. Stolen from people who worked their entire lives to accumulate it. The tactics have evolved dramatically. Scammers now use artificial intelligence to clone the voices of government officials. They use information stolen in data breaches to reference your real name, your partial account number, your actual address, to make the call seem legitimate. They build websites that look pixel for pixel identical to official government portals, and they are specifically targeting seniors who they know are likely to receive new benefits and communications following a major Supreme Court ruling. The expected ruling on June 5th will confirm mandatory fraud reporting requirements for financial institutions and expanded federal funding for elder fraud investigation and prosecution. Banks and credit unions will be legally required to flag suspicious activity on senior accounts and will have legal protection to act on what they see without waiting for explicit instruction. But here is the warning I need you to hear clearly right now before June 5th arrives. Within hours of this ruling dropping, scammers will be calling seniors across America. They will tell you that you need to call a number immediately to claim your new benefits. They will tell you there is a processing fee. They will tell you that you need to verify your Medicare number or your Social Security number to receive your updated payment. Every single version of that call is a scam. Legitimate government agencies do not call you out of nowhere demanding immediate action. They do not charge processing fees. They do not ask for your account numbers over the phone. Write this down. The National Elder Fraud Hotline number is 1-833-FRAUD-11. If you receive any suspicious call, hang up immediately and call that number to report it. Share that number with every senior you know before June 5th. Now let me bring this home with what you need to do right now. Today, Before this ruling lands, Step 1. Call your Medicare plan today. Not next week, today. Ask about your drug cost maximum and which of your medications are in the negotiation process. Step 2. Log into ssa.gov and verify your Social Security account and benefit information is current and accurate. Step 3. Pull the inspection report for any nursing home currently caring for a loved one at medicare.gov. Step 4. Call your bank and ask about elder fraud protection protocols now in place on your account. Step 5. Write down and share the Elder Fraud Hotline, 1-833-FRAUD-11. Step 6. Subscribe to this channel and turn on notifications because when June 5th arrives and this ruling drops, the breakdown of exactly what it means for your specific situation and exactly what actions you need to take will be the first video that goes up on this channel. And the seniors who are subscribed will have that information the same day. 7 justices are about to stand up for you. Be ready to stand up for yourself. Drop a comment right now and tell me what state you are in and what benefit matters most to you. Medicare costs, Social Security, nursing home safety, elder fraud protection. I read every single comment and your responses shape the content this channel produces. June 5th is coming. You are ready.